Meaning of the word admission. Admission has been defined in the Evidence Act as statement, oral or documentary, or conduct which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and in the circumstances mentioned in the Act. This is talking about Section 20 of the Evidence Act. This very provision, there seems to be a sort of an ambiguity. Talking about statement, oral or reading or by conduct, which makes suggestions. And the suggestion is an inference as to any fact that is an issue or relevant fact that is an issue, which is made by any of the persons. This hasn't given me exactly what I'm looking for. Rather, when we look at case laws, there are a lot of case laws that have actually explained the meaning of the word admission. For you to understand the word admission, you must be able to separate it from statement made. If somebody comes here and says, I'm a law student, that's a statement. You don't talk about admission. Right. Admission will come when the status is an issue. And maybe somebody comes to say, okay, this is a student of high grade. I have his matriculation number. Then his status is now in question. And somebody confronts him, you told us you're a law student. So if he turns back to tell you, no, I'm a student of high grade, I'm just here, you will say no. Why? Because you have already made a statement. As at the time you made it, there was no issue. We believed you. But now that there is an issue, you are bound by your statement. In other words, that thing that you said earlier has become an admission against you because it's in fact an issue. An issue has arisen. So a mere making of statements where no issue has arisen is not what. An admission must be able to show that the person who is said to have admitted that fact has acknowledged it one way or the other, or he has done what? He has accepted that fact. If he has not accepted that fact, there is no admission. Admission simply means what? Accepting. You have accepted something. Oh, I said it, I'm sorry. Oh, I said it and I stand by it. It is what? Is admission. Accepts a state of being. That state of being could be a statement he had made before. It could be something that had been done on his behalf. That's why we had conduct. And it could be a document he had written. What types of admissions? We have formal and informal admission. When you talk about formal admission, formal admission means that admission that is made in document. Which document? Pleadings. Those admissions that we make when we are doing a matter before a court of record, such as the High Court, where everything about the facts to be presented are put down by way of pleadings. The claimant has pleaded his facts, and the defendant has also pleaded his own fact in which document? In his statement of defense. So that is what? Formal. So if I, as a defendant, in my statement of defense, and I say, the defendant hereby admits paragraph 1 of the statement of claim. That means I think it's good. I've agreed with him. And remember that in a statement of defense, there is an introduction or a preamble where I, as the defendant, have already said in my paragraph 1 of statement of defense, said as is hereinafter admitted, the defendant hereby denies every and each allegation of facts contained in the statement of claim as if same were set out and hereby denied seriatim, and the defendant shall put the claimant to the strictest proof thereof. In other words, my first language is that I am denying everything he said, except the one that I have admitted. It could be in his paragraph 1 of the statement of claim. I said, I am a businessman. I don't have quarrels with that. I say the defendant admits paragraph 1 of the statement of claim. That is what? Formal admission. So means what? Something that can no longer require proof. In other words, what is formally admitted requires no further proof. So I'm not going to label myself to prove that this man is a businessman or to tell him to prove that he's a businessman. I'm not going to label again to put him to prove that the father was the original owner of the land. Why? Because I had already admitted that very fact. And one may want to ask, after this admission, haven't you lost the case? The answer is capital no. So, the rule of the court or the judicial precedent that stipulates that what is admitted requires no further proof only pertains to what? Facts or issues, but not the entirety of the case. For instance, I might have admitted here the land was paid to my father, but at a particular point in time when his father could not redeem, his father approached my father and they had a discussion and he saw the land. Do you understand? So that's a new fact. So by saying so, I have narrowed down the issues. I have restricted those that I have admitted. Those ones require no further proof. What will require proof now is that his father came to my father. He said he can no longer redeem. They discussed and my father bought. Simple. That's become the issue in trial. In other words, admitted fact does not mean that you have admitted the entirety of the case. What is informal admission? Informal admission is also that kind of admission that is contained in your pleadings. But they are called informal. Why? Because the admission that a party has made unwillingly, involuntarily. Why do we say unwilling admission or involuntary admission? It could be involuntary in the sense that maybe his counsel didn't know what to do. His counsel didn't plead his facts well. Whereby maybe something has been said in the statement of claim and the defendant has failed to deny it. That is involuntary admission. It can also arise where the defendant says, this thing he's talking about, I am not in a position to either admit or deny his own fact. When a fact is made in a statement of claim, the rule is that denial must be in toto. Denial cannot be evasive. Evasive like he said, I gave this person money. And then in my defense, I start saying something like, he's always claiming he gave people money. Have I denied what he said? I have not. That is a passive denial. And it means what? That I have admitted it involuntarily. And another mode of involuntary admission is when a defendant fails to file his papers. You have been served, but as a defendant, you have failed to file a memorandum of appearance, and you have also failed to file your what? Statement of defense. In which case, the claimant can file a motion, depending on what the course of action is, asking the court to give him judgment. Or if the declaratory relief that is seeking, he can ask the court to set the matter down for him to prove his case. Why? Because on my side, there is default. Default of appearance and default of pleading. So in a situation like this, it is taken that I have not what? Involuntarily admitted the fact. The question is, does the law or the rule that applies to formal admission also apply to informal admission? Did you get my question? The answer is no. Why? Because it's like the court trying to give you a little leverage. Does it then mean that it can be proved? The answer is no. Why? Because the Supreme Court has said that where there is involuntary admission or default by a defendant from filing his processes, that the claimant will be obligated to prove his case on a minimal standard. He must say something on a minimal standard. The fact that I didn't file anything does not mean that I cannot cross-examine him when he's giving his own evidence. So that's the law. For that, you can see the case of Folk Sentences, Folk Sentences, F-O-L-K Sentences Limited against Gapuma. Folk Sentences Limited against Gapuma. This case is reported 217, 8 Nigerian Weekly Law Report, part 1566, page 150. While the case that illustrates formal admission is the case of Aladun, A-L-A-D-U-M, Aladun against Obu. There are conditions. The court to say, yes, a fact has been admitted. And these conditions are: 1, the fact to be admitted must be clear and unequivocal. At least this makes a lot of sense. That in fact you are said to have admitted, that you are admitting it in clear terms. Somebody asks, what is your name? And you get angry, I don't know. At times you're doing a cross-examination. I've done that a couple of times. And when the witness feels that you have battered his case, every other thing you ask him this, I don't know. He's already angry. It's not that he doesn't know. He knows. But the fact that he has said I don't know could just be he's being mischievous. He's concealing facts. It doesn't mean admission. So admission must be clear and unequivocal. Second condition, it must be relevant to the facts in issue. For there to be admission, that thing that is said to have been admitted must relate to a live issue in the matter. It must not be extraneous. It mustn't be extraneous. It must be something that is directly linked to the fact in issue or directly in issue itself. Somebody says the land belongs to my father. And then another person says whether it belongs to your father or not, I don't know. I bought it from Mr. Z. That's not admission. But it's a different thing if maybe the person giving evidence says, I'm a boundary neighbor to the land in dispute. Therefore, I know that this land does not belong to Z. It belongs to this man's father. So, this person who has said it, when he gets into the witness box for cross-examination, he cannot change his sentence. He can't change his statement. Because he has said, I'm a boundary neighbor. It means now that his evidence is what is relevant to the case of the person whom he is witnessing for. So that's why the law is placed as a second condition that fact to be admitted must be what? Relevant to the fact in issue. And then again, a fact must be admitted by somebody who has knowledge of the fact. That's where we would know those who are summoned witnesses at times. Those bought witnesses. There are professional witnesses. They don't know anything about the matter, but give them money. They will come to court and start telling stories. For you to say that somebody has admitted the fact, the person must be shown to have knowledge. The rationale. Why? The justification is that if you don't have this law in place, it means that somebody will just come and fabricate something. That means that you just come and... So when somebody comes and starts giving this kind of evidence, try to corner him to show that he doesn't even have knowledge of what he's talking about. He doesn't have the knowledge. admission helps the court in respect of the admitted issues. You know why? So that the court will not waste precious time, going into the proof or listening to what has already been proven. Admission also helps the other party in whose interest the admission has been made. It helps the case of that very party. And again, we can say that admission is the best evidence in trial. Why? Because any fact that is admitted, what you simply do is to do what? To remove it. The Evidence Act has made provision for classes of admission. So the first one is admission against self-interest. Admission against self-interest. This admission can be made in two ways, or even in a number of ways. If I am making admission that is against me, that's admission against self-interest. If, for instance, in that example I gave, the plan was paid to my family, his father came, they discussed, before my father could buy, my father died, his own father died, and he'd be under cross-examination and I'm asked, till today, have you paid for the land? And I say no. What does that mean? I'm simply admitting the land is still their own. So it's admission against interest. Another way that you can have admission against self-interest is when you have a witness who comes to court to give evidence that supports your opponent, your own witness. He comes to court to give evidence that supports your opponent. In that case, you are bound by that very admission, except to act fast. We can act fast by relying on the extant provision of the Evidence Act to make an application that the Honorable Court treats the witness as a hostile witness. When the witness starts giving evidence against you, maybe they have seen him behind the scene. But the day he was driving by, close to his opponent's house, saw three of his witnesses. Among them, they were still drinking with them. Come down the glass. I want to say, you see this? Then not try to bring such a witness to court, because he's already on the other side. So, a witness may be somebody who is giving evidence against you, not voluntarily, either because he's not intelligent. And that's why, before you select witnesses, do what? Screen them. Whereas a member of the family cannot make admission that binds on his family, the family or family head can make admission that can bind on individual member of the family in respect of jointly owned property. You know why? Because of the status of the family head. So another member cannot just go to court and say, it's not our land, it's their own land. Do you understand? Even if the court admits it, the family head can come and say, we didn't send him. Why? Because customarily, this is the person who is the custodian of the rights and obligations in the family, as well as all the property in the family is in his custody. So, but when he comes to say something that affects the family, then it applies every member of the family without more. And that's why most of the times it's difficult when the family head has been bribed. Except you find out and then somehow try to scuttle the process before the damage is done. We also have admission by counsel. A lawyer, your lawyer in a proceeding has an extent to which he can make admissions for you. But it is not a kind of unlimited right to do that. He must do that with your consent, and where your consent cannot easily be obtained, then that means he can make it to your best interest. He has to consider what is the best interest of my client before he can make any admission that will be binding on his client. If not, the court in the end, or appellate court can do what? Can cancel whatever the counsel has done. I did say that under the law, a counsel has the right to make admissions on behalf of his client. So it's either called admission or compromise. I want to talk about admission has to come in two ways. The first is that before counsel can make admission on behalf of his client, he must have been so authorized. He must have obtained the consent of his client. If not, you will just see maybe a counsel will just come to court in a criminal trial and say, "My Lord, send my client to prison. He committed the offense." No counsel has right to do that, except he is expressly authorized. And then again, where consent cannot easily be obtained from client, where consent cannot easily be obtained from client, counsel has to use his discretion to ensure that whatever decision, like in terms of admission or compromise, that he wants to make on behalf of his client must be in the best interest of his client. For instance, if there is need for negotiation and a client is not available to tell you the limits of what he wants, and depending on the facts of the case on the ground, counsel can make admission based on what could be in the best interest of the client. And talking about the best interest of the client, counsel also has to take into consideration the peculiarities of the case, which may be in form of maybe the case being in favor of his client. If you are doing a case that is in favor of your client and there is need to negotiate, that means you have what? A better bargaining power to negotiate for your client. I'm going to give an example. So if as counsel, you go for 50-50 or go for something less beneficial to your client, you'll be said to have done what? Abused that right. And your client can contest it and get it set aside. Now, on the other hand, if, for instance, your client has a bad case, maybe it's a matter that judgment had already been given, the much you can do is to get the best you can for your client. Do you understand? So if maybe your client will come and say, "Look at what I want," you as a counsel will see the client down and say, "This is not feasible." Because by the rules, professional ethic rules, if you advise your client to the contrary, you may be punished by engaging in conduct unbecoming of a lawyer. Maybe your client, looking at the situation, is not entitled to any particular thing or to a level of what you are negotiating. And then in the end, you will lead him astray, because other people may back out and say, "We are not interested." When they back out, you have lost the opportunity of rescuing something for your client. And that is also what? Misconduct. It's a conduct unbecoming of a lawyer. I give you an example. There was this matter I inherited from someone who felt he was done with practice. So he wanted me to go ahead and do the appeal. And the appeal was against. When I was given the matter, the client thought that the case was still live. He never knew that something had been done, that the former lawyer had compromised. So what happened? I looked at the judgment. I called the counsel first. Then I didn't even know who the client was. He was supposed to introduce the client to me later on. So I told the judge, the lawyer, that from the judgment I'm seeing, it's a consent judgment. And you don't apply to set aside consent judgment. You don't even appeal against it, except you can show fraud. The man told me that he never knew anything about that. So we started searching, and we discovered that the former lawyer who was doing the matter one barrister at a particular point in time was approached. He could not resist the temptation. So he agreed to play along with. When that happened, judgment was given, and in such a funny manner, because a property was involved. This client happened to be of an Igbo extraction, so he bought property at a very vital location and said the property by all means. He went to the family, they said, no, we have sold it to so person. So after he said, oh, you sold property to an Igbo man, no problem, take money, let him come out, let's go to court. So he forcefully took the land. So at the time he also had to handle the lawyer. He settled the lawyer. And the lawyer in court signed terms of agreement that his client has given the property to the other party. And the question was, how do we prove compromise? One, nobody can litigate a matter for about 6 years, and then all of a sudden he surrenders. He has the title deed, he has the conveyance, he has everything going for him. You will simply surrender to the opponent, no consideration. He didn't sign the papers, it was the lawyer that signed, and the lawyer had the gut. So when the man discovered what happened, he slept and died. The wife took over the matter, and it was the wife that I started representing. Now, we had to file a fresh suit. That lawyer had the temerity to come to testify, or he had power, he acted within his authority to make admissions and compromise. Right. I asked him, what kind of authority did you have? Express or implied? He said it was implied. Good. This property, did your client buy it? Did he pay money for it? He said yes. How many plots are involved? About 4.5 plots. And in your wisdom, you're taking a decision that your client couldn't even get a foot of the land. So in the end, I also put it to him, did you know that your conduct amounted to professional misconduct? I just said, don't ask him that question, don't ask him that question. I said, my Lord, with due respect, you can record me and overrule me. We argued that for almost an hour. If, for instance, you feel my question is irrelevant, you just can't say it on your own. You record it. When you record it and you're making it, say, counsel said, make so submission. It is my view, backed by law, that counsel submission is of no effect. The judgment said that quite all right, the property was conveyed legally to my client. Everything was done in favor of my client, but that we have not been able to prove that my client did not consent. She forgot that we brought a suit. And in that suit, you're giving judgment. If my client consented, would he have sued? So we are on appeal over that very matter. So we are talking about admission by counsel. It has limits. It is not an open-ended right. When you make an admission, it is not a conclusive proof of the case. Admission may be a conclusive proof of a fact, one of the facts in issue, but it is not a conclusive proof of the entire case. That is one. Then again, when the action is declaratory in nature, somebody has sued, asking the court, declare me as the winner. Declare me as the owner of so property. Declare that what this man did was wrong and unbecoming of a lawyer. And maybe the other party failed to appear. He fails to give evidence. Even though if he comes to defend the matter, another cross-examination admits, yes, sir, I did it. It doesn't stop you from going ahead to prove that he did it. But what the law says that the standard of proof in such a situation is what? On minimal standard. That means you don't require full standard to prove what has already been admitted. Finally, we want to talk about admission based on agreement. If we have a written agreement, that agreement binds us for all purposes. If an issue arises, the other party can tender the document, the agreement, to show the clause where I had said I will do this if this happens. That becomes what? Admission. If that agreement is made without prejudice, it simply means parties do not intend that the agreement will be binding on them. In that situation, document made without prejudice becomes what? Inadmissible in law. So far, so good. I'll tell you when next I'll be here. Thank you.